Court is now in session. Please be seated.
Good afternoon. You may begin.
Good afternoon, Justice Valhura, Justice Straine, Justice Breault. Raymond D. Camillo for the appellants. Here with me this afternoon, is my partner, Travis Hunter.
Good afternoon.
Justice Valhura, may I proceed?
Yes. Yes.
Your Honors, this case is an action by an alleged member of a limited liability company seeking books and records of the limited liability company. The matter was tried before the Court of Chancery. The primary issue that was litigated in the Court of Chancery was whether the plaintiff was a member of the LLC at the time the action was filed. The trial court found that he was and granted him access to the books and records that he sought. The trial court's conclusion was hinged on its finding that an exchange of emails between the parties on February 14th and 15th constituted a mutual written agreement to terminate a service agreement between the parties. However, neither the February 14th nor the February 15th email mentions the service agreement at all. In fact, plaintiff sent the February 14th email in connection with an entirely different proposed agreement and proposed transaction. Moreover, the Court of Chancery failed to consider key evidence which demonstrated that there was no mutual written agreement as of February 15th, instead relying on a recital in an agreement that was never signed and certain extrinsic evidence of conduct.
So, Mr. DiCamillo, your main argument is really a question of was there mutual assent? And it's a clearly erroneous standard that we're applying here, is it not?
It is. The answer to both Your Honor's questions, Justice Valhura, is yes. The primary issue is whether there was mutual assent. This court in the Eagle Force case held that that is a question of fact, and as a question of fact, the standard of review is clearly erroneous. And I'm prepared to talk about why I believe the conclusion was clearly erroneous.
Well, before you get there, what is the relief that Straine Dental might have available to it if we are to reverse? I didn't see any requests for relief by Straine Dental in the Court of Chancery.
Justice Straine, you're right that there was no request for relief by Straine Dental. Straine Dental was the defendant. What was litigated primarily was whether or not Dr. Breault was a member of the limited liability company. The Court of Chancery found that he was. If this court were to reverse, thereby holding that he was not, then that conclusively establishes that he was not a member of the LLC.
The books and records have been produced.
The books and records have been produced, Justice Straine.
So there's no relief on the table at this point. Is that correct?
The relief would be a declaration that he was not a member and is no longer a member.
Would Straine have been able to counterclaim for declaratory relief in the action below?
It's an interesting question, Justice Straine. I think they would have been. However, since it was a books and records case, they may have been faced with an argument from the other side that this is a books and records case. It's a summary proceeding. The one issue is whether or not you get the books and records. So there would typically not be the opportunity to counterclaim in a books and records case, but the way the case was litigated in the Court of Chancery, really the only issue was whether or not Dr. Breault was a member.
Well, and I understand that it would be atypical to have such a counterclaim in a books and records action. But we also see this dynamic addressed with motions to stay the Court of Chancery's order, either in Chancery or in our court. But in this case, Straine Dental didn't choose that route. Instead, it produced the books and records.
That's correct, Justice Straine.
There were remedies available, potentially available to Straine, short of appealing this case, which to some appears to be moot.
I think the remedies that were available to Straine that it could have taken on, where it could have moved for re-argument, As your honors know, motions for re-argument are rarely successful. It did not move for re-argument. It could have moved to stay the judgment pending the appeal. It chose not to do that. It produced the books and records and decided to move forward with the appeal. But the issue about whether or not Dr. Breault, as a member of the company, remains a live and actual controversy, and that's why this appeal is not moot, as the other side has contended.
Thank you.
So let me give a little bit of background, which puts this dispute in context. Straine Dental Management, LLC, is a Delaware limited liability company which is in the business of providing services related to dental practice growth management and dental practice sales strategies. At the time of the events relevant to this litigation, Straine Dental Management was governed by the Straine Dental Management, LLC Limited Liability Company Agreement, dated as of June 20th, 2017. And that's found at A219 to 256 of the appendix. Prior to the events in the litigation, Dr. Breault was a member of the LLC. The LLC also provided services to Dr. Breault's dental practice pursuant to a service agreement dated January 1st, 2018. That's found in the appendix at A257 to 299. Certain provisions of the LLC agreement and the service agreement are relevant to the issues on appeal. First, Section 7.2A of the service agreement, which is at A270 and 71. That provision provides that the service agreement may be terminated at any time by the mutual written agreement of the parties, or upon at least 90 days written notice by either party to the other. Then there's Section 7.3 of the LLC agreement, which is found at A244. And that provision, Section 7.3A, provides in part that in the event that a Class B, Class C, or Class D member's dental practice ceases to be a client of the company shall immediately have the right at its option to purchase all of such members' membership units, except as set forth in Section 7.3B. And 7.3C provides that the company needs to exercise that right to purchase the members' membership units by providing written notice to such member within 15 days of discovering the triggering event. So let's focus on the concept of mutual written agreement, which is what the Court of Chancery found that the February 14th and 15th emails did constitute a mutual agreement to terminate the services agreement, and that's the finding that we challenge on appeal. The Court of Chancery's conclusion that Dr. Breault was still a member of the LLC at the time he filed this action is based on the following findings. An exchange of emails between Dr. Breault and Carrie Straine, who was the CEO of Straine Dental Management, on February 14th and 15th, 2002, constituted a mutual written agreement to terminate the service agreement pursuant to Section 7.2. According to the Court of Chancery, that email exchange constituted a triggering event pursuant to Section 7.3A of the LLC agreement. Again, according to the Court of Chancery, Straine Dental Management had 15 days from February 15th to exercise its right to purchase Dr. Breault's units. And according to the Court of Chancery, Straine Dental Management did not exercise that right until April 8th, which in the opinion of the Court of Chancery was too late. Let me now discuss why that conclusion was clearly erroneous. As I discussed with Justice Valahura a few minutes ago, the key issue is whether there was mutual assent to terminate the agreement. And the parties agreed that mutual assent is required to terminate the agreement. The parties also agree on the elements necessary to establish mutual assent. If you look at pages 16 to 20 of our opening brief and pages 23 to 24 of plaintiff's answering brief, they read very similarly. In fact, both parties rely on this court's opinion in Jaslov versus Falborn from 1924. And that case establishes that one party cannot agree to modify or terminate unless the other party assents. Minds of the parties must meet by offer and acceptance. Mere negotiations cannot affect a prior contract. and this is a quote from the opinion, "There can be no cancellation of a contract unless it is clearly shown that such was the intention of both parties." So we agree on the legal standard. The Court of Chancery's opinion, however, does not deal with the concept of mutual assent at all. And the evidence before the court at trial demonstrated that there was no mutual assent. Let me go through the reasons why. First, neither the February 14th agreement, let me start over. Neither the February 14th email nor the February 15th email mentions the service agreement at all. There is not one reference to the service agreement in either of those emails. The reason the February 14th email was sent was because prior to it being sent, Straine Dental Management and Dr. Breault had entered into a letter of intent regarding a potential transaction under which the company would acquire the non-clinical assets of Dr. Breault's practice. The February 14th email sent by Dr. Breault was simply him informing Straine Dental Management that he determined not to proceed with that potential transaction. Dr. Breault conceded that this was the point of the February 14th email in the trial court. In his opening pretrial brief at page 1, found at A64, and in his trial testimony at A115 and A147 to 49. And in his answering brief on appeal, he wrote in page 9, quote, "On February 14th, 2022, Dr. Breault informed the company that he would not be proceeding with a letter of intent and a draft asset purchase agreement." That was the intent and the purpose of the February 14th email, not the service agreement. Second, the language of the February 14th and 15th emails shows that there was no mutual assent to do anything as of February 15th. In the February 14th email, Dr. Breault wrote in the future tense. He wrote, "I understand that things will need to get unwound, and I will cooperate fully." In his February 15th response, Mr. Straine continued in the future tense, indicating that a representative of Straine Dental Management will email you the mutual release agreement. And Mr. Straine's email contemplated the execution of an agreement in the future, stated upon execution of the mutual release agreement. All that's found at A301 and 302. Third, the Court of Chancery's opinion did not discuss at all key evidence that the service agreement had not been terminated. Following the February 14th and 15th email exchange, Straine Dental Management sent Dr. Breault a proposed membership unit, redemption, and mutual release agreement. It's at A303 to 308. Section 1.3 of that proposed redemption agreement, found at A304, says, "Effective as of the effective date, the company and seller parties hereby agree that the service agreement," I'm skipping some words, "shall, subject to 7.3 of the service agreement, automatically be terminated and be of no further force or effect without any further act required on the part of any of the company or seller parties or their affiliates."
What about the recital on A303? And I understand the agreement was never entered into, but it says, and the company and the corporation have mutually agreed to terminate the service agreement, thereby causing the corporation to no longer be a client of the company.
The Court of Chancery relied on that recital, Justice Valahura, and said nothing about Section 1.3 of the proposed agreement in its opinion. But let me focus on the recital. And I view it this way. I think a simple example would put it in context. So Mr. Rubiak and I are adversaries in litigation. We have a phone call, and he says, "Why don't you propose a briefing schedule?" I draft a stipulation. A whereas clause in the stipulation says, "Whereas the parties have agreed on the following briefing schedule." And then I lay out a briefing schedule. We haven't talked about it. We haven't agreed on it. I send it to him. He says, "Well, we haven't agreed on this briefing schedule." The fact that I put a recital saying that we agreed to it has no meaning until the stipulation or agreement is actually agreed to. So
But there were other facts, weren't there, though? For example, the doctor's access to the analytics dashboard was cut off shortly after the February 15th email. I mean, wasn't that part of the factual mix that the Vice Chancellor considered?
It was part of the factual mix that the Vice Chancellor considered. Certain services were starting to wind down. The analytics dashboard appears to have been the first thing that happened. However, Dr. Breault conceded that some of the services did continue into March. That's on page A156 to 60.
But is that because those services couldn't be unwound quickly? They were payroll and other types of things that required a longer period to unwind?
Some of those things were, Your Honor, Justice LeGros. But the record before the court and the facts were that services were still winding down into March.
But if services were winding down, doesn't that imply that the service agreement had terminated?
I don't believe so, Justice LeGros. I think what it suggests is that the parties, and certainly Straine Dental Management, thought Dr. Breault was going to sign the redemption agreement and things were going to be wound down. In fact, the effective date in the proposed redemption agreement was February 28th. So in the minds of the parties, it looked like the relationship was going to be severed. However, it wasn't. He never signed the proposed redemption agreement. The fact that there was a recital that said the parties have agreed really has no meaning until the agreement is signed. And what I think is perhaps the clearest example of the Court of Chancery's conclusion being clearly erroneous is the fact that it did not deal with Section 1.3 at all in its opinion. And that wasn't because Straine Dental Management didn't bring it to the court's attention. It made the argument in its pretrial answering brief at page 7, A82, in its post-trial answering brief at page 2, page 2 and 6 to 8, to A193, and 197 to 99. And the provision itself was shown to Dr. Breault at trial, A153 to 154. Dr. Breault ignored Section 1.3 in his briefing below and ignored it in his answering brief on appeal, and the Court of Chancery made no mention of it at all in its opinion. And because of that, we believe all the Court of Chancery relied on was the recital and this extrinsic evidence of conduct, instead of grappling with the fact that the February 14th and 15th emails don't mention the service agreement at all, and that the proposed redemption agreement clearly indicated that the service agreement had not been terminated.
What is the relevance, if any, of the statement made by Carrie Straine on February 15th about prepaid services being refunded, and apparently they were calculable as of that date? Does that suggest that the services, by and large, were cut off and that Dr. Breault really wasn't a client any longer?
It does not, Justice Traynor. What Mr. Straine referred to in the email was assuming that the mutual redemption agreement was signed, the service agreement would have been terminated. The services were prepaid, and in fact, the amount of the service, the monthly fee, $49.50, is in the service agreement, I believe, at Section 6.3 of the service agreement, A270. There was a prepayment, so it's like rent, paid the first month and the last month in advance. So there was Mr. Straine was saying, once this is terminated, once we do sign this up, get the relationship terminated, we'll return the $49.50 that you prepaid for March. I see I'm well into my rebuttal time. Unless your honors have any questions, I will save what I have remaining for rebuttal.
That's fine, thank you.
May I proceed, Justice Valera?
You may.
Good afternoon. May it please the Court. My name is R.J. Rubiak, and I represent appellee Dr. Robert Breault in this matter. I'd like to start off this afternoon addressing a question that was brought up by Justice Traynor very early on. And what is the relief that SDM is seeking here? And SDM replied, they're seeking a declaration that Dr. Breault is no longer a member of SDM, What effect would that have on Dr. Breaux? Well, it would strip him of his membership rights. But not only that, he still holds Class B and Class D shares in the LLC. So that would be stripping him of his shares and membership interest without providing just compensation or value for those shares. And so that goes towards Appellee's mootness argument. You heard SDM agree that the books and records that were at issue at the court below, those were turned over, those were produced. By doing that, SDM implicitly recognized Dr. Breaux as a member of the LLC, because if he wasn't, then he wouldn't have been entitled to those books and records. But by doing so, they implicitly recognized him as a member still. So, because there's no existing controversy, this case is moot. But putting that aside, the plain language of the operative agreements, the emails between Carrie Straine and Dr. Breaux, and the subsequent conduct of the parties show that there was a mutual assent, intent, and agreement to terminate the service agreement in February of 2022, and SDM did not even attempt to exercise its call right until almost 2 months later, well outside the applicable 15-day time period. As such, the Chancery Court correctly determined that Dr. Breaux, as a member of SDM, was entitled to SDM's books and records. So, as Your Honor pointed out, this is a clearly erroneous standard. And what that means is great deference is given to the Chancery Court's findings of fact, and they should not be overturned even if there's two reasonable interpretations of those facts. And that also includes the credibility of the witnesses at trial. So you heard my colleague state there's two operative agreements. I'm sure we are all very intently familiar with them and how they operate, and they interconnect and play off of one each other. But it is black letter law that in order to terminate a contract, the parties must come to a meeting of the minds and agree to discharge all of the other parties' remaining duties of performance under an existing contract. Determining the intent of the parties is a question of fact. And the Chancery Court correctly determined that Dr. Breaux was a member because the service agreement was terminated in February 2022, and SDM did not timely and properly exercise its call right. So what evidence was before the Chancery Court? We have the emails. On February 14th, 2022, Dr. Breaux sent an email to Carrie Straine in which he indicated he would not be able to execute on a new asset purchase and contribution agreement, and he understood things would need to get unwound. The following day, on February 15th, Carrie Straine responded that he was sorry to learn that Dr. Breaux did not want to move forward with SDM and wanted to unwind the relationship. Unambiguously, he stated, quote, "I accept your decision." But this was not the only evidence before the Chancery Court in the trial below. Dr. Breaux testified at trial that his decision not to move forward with the new asset purchase and contribution agreement would mean that everything would be ending, the relationship with Carrie Straine and SDM, as well as the agreements governing the relationship. If there's any ambiguity in the February 14th and 15th emails, it must be construed against SDM. It's important to note that SDM did not produce Carrie Straine in response to Dr. Breaux's 30B6 deposition notice, and further, Carrie Straine did not appear and testify at trial. Thus, any understanding of Carrie Straine, which is argued by SDM, is not based on any facts of record, but is pure speculation. In fact, Dr. Breaux at trial testified that he understood Carrie Straine's email to mean that he and Carrie Straine were in alignment, that the relationship was terminated. Now, there was some discussion about the mirror image rule and conditional acceptance. So I'd like to look at Carrie Straine's email even further. Following the acceptance of Dr. Breaux's decision, Carrie Straine states, "Upon execution of the mutual release agreement, Straine will pay you the total redemption price of $22,500 in addition to the $4,950 for your prepaid final month of service." His response did not condition termination of the service agreement on signing the mutual release. Now, while both parties cite to the Josloff decision, this case is not like the factual situation that faced this court in Josloff. In that email, Straine did not express a willingness or an intent to perform and provide the services under the service agreement. In fact, those services were terminated and not provided, some even terminating in February, even though Dr. Breault paid for them through the end of the month. Now, Williston on Contracts directs that mutual assent to terminate a contract can be demonstrated not only by the language of the parties, but also by the parties' conduct and all surrounding circumstances. I want to address the redemption and release agreement, which was recently discussed. That agreement indicates that the service agreement was terminated effective February 28, 2022, i.e. the end of the service period Dr. Breault had prepaid for on February 1st, 2022. Now, it also contains this whereas clause that references Section 7.2 of the service agreement regarding termination by mutual written agreement and reflecting that the parties had mutually agreed. While recitals may not be substantive to the contract, Erdan recognizes that recitals indicate the background of the contract.
I'd like to ask you at least one question about the recital. The Vice Chancellor referred to that as a use of the past tense, and I think a grammarian would probably take issue with that characterization. It's really the present perfect tense. But that's a preface to my question. If I told you that my law clerks and I have agreed to meet for lunch after oral argument, is that something, does that use of have agreed relate to something that happened in the past? I mean, the action, having lunch, is actually in the future, correct?
Correct, Your Honor.
So should we rely upon this recital in any respect?
I think we can in this case, because not only do you have that recognition that the service agreement was terminated in that whereas clause, the parties next acted as though it was. And so I'd like to just respond to my colleague's hypothetical where he said, so-and-so, the parties have agreed to the following briefing schedule. I would agree that if we did not act in accordance with that briefing schedule, that whereas clause could not be used as evidence of what had transpired. However, if we started acting as if those proposed deadlines were in place, then that recital would have meaning and would be used as evidence to show that the parties had agreed as indicated in that recital and in that whereas clause.
Well, let me change the hypothetical, or give you another example of the use of that tense. Sales contract. Seller has agreed to sell and buyer has agreed to buy the following described property. Doesn't mean the sale has occurred, does it? Until the contract is executed.
Not necessarily, Your Honor. I think that the parties' actions play into that hypothetical. If they don't move forward with that sale, then yes, Your Honor is correct that is not evidence to show that the sale had been consummated. But again, if there was a down payment, if there was some sort of action by the parties, both parties, which is the same in this case, both parties began acting as if this service agreement had terminated, then I think that could be used as evidence to show the understanding and the intent and the assent of the parties to that contract.
But if that's what that whereas clause means, then why is section 1.3 in the release agreement?
The agreement was a universal agreement. It was unwinding everything between the parties. And just as a brief background, Dr. Breault was not just some passive member in SDM. He was their chief clinical officer. He worked tirelessly to structure a financial transaction that ultimately resulted in that proposed asset purchase and contribution agreement that he didn't go through with. But there was a long history. So there were multiple items that needed to be unwound, terminated, ended between the parties, and that mutual redemption and release agreement was all-encompassing. Now, just the fact that they did not agree on, say, the purchase price of Dr. Breault's membership units does not mean that they didn't agree to severance of the service contract. Because again, we go back to the actions of the parties.
But my question's a little bit different, which is if the whereas clause was reflecting a past agreement to terminate the service agreement, then why does section 1.3 say effective as of the effective date, the parties hereby agree that the service agreement shall be terminated?
So the release and redemption agreement, that was drafted and sent over by SDM. They would have had more information to provide the court as to Your Honor's question. However, they didn't produce anybody with knowledge to a 30B6 deposition or somebody at trial to answer those questions. Now, I understand that the whereas clause cannot be read to make one of the provisions of the contract superfluous, and we're not arguing that. What we're arguing is that whereas clause is just additional circumstantial evidence to show what the February 14th and 15th emails were regarding and how they actually formed that mutual written agreement to sever and terminate the services agreement. Justice Valahura mentioned that the dental intelligence dashboard was terminated, but that some services did continue into March. That was in accordance with section 7.3 of the services agreement, which pertains to continuing obligations that accrued in the prior month. So, for example, payroll, accounting, things that cannot immediately be terminated. The financial books and records for February would not be available until February's month end, and reports ran, and then they would be available the following month at some point.
And wasn't there evidence regarding your client reaching out to various vendors? Can you provide some detail on that?
Yes, Justice Valahura, there was. Dr. Breault testified at trial that on March 1st, Vera Powell, who was the director of operations of SDM, emailed Dr. Breault to acknowledge that he had reached out to the payroll vendor in February to start the transfer of those services from SDM to now his Cromwell Family Dental would be taking over. Now, as to the second issue on appeal, under a de novo standard of review, SDM failed to timely and properly exercise its call right. Under Section 7.3 of the LLC agreement, SDM could exercise its right to purchase Dr. Breault's shares by providing written notice to Dr. Breault within 15 days of the dental practice ceasing to be a client of SDM. Here, the triggering event, the termination of the service agreement, and cessation of Cromwell Family Dental being a client of SDM occurred in February of 2022. SDM did not even attempt to exercise its call right until April 8th, 2022, almost 2 months later. SDM's argument that Dr. Breault's March 16th email triggers the 90-day notice period is nothing more than an attempt at gamesmanship. As discussed earlier, both parties knew and acted as if the service agreement was terminated in February 2022. And so there's no reasonable basis for SDM to state that the first time it received notice was on March 16th. Dr. Breault's email does not state that he is terminating the service agreement. What he says is, since the service agreement is terminated, past tense, he was requesting his financial materials. It's merely confirmatory of what had transpired in February. Additionally, as mentioned before, the dental intelligence service as well as other services had begun to wind down in February. And as just mentioned, the March 1st email from the Director of Operations of SDM acknowledged that Dr. Breault had began reaching out to vendors. But even if the triggering event occurred on March 16th, SDM still did not timely send notice of its call right, as that notice purportedly was sent on April 8th, 2022. And further still, it was not sent in accordance with the method of notices as set forth in the LLC agreement. Section 12.1 states that the notice shall be deemed sufficiently given if by personal delivery, fax, or certified registered mail. Here, SDM sent the notice by FedEx and email. Now, this is similar to the case Travelers Center versus Breault. In that case, involved notice for nominations of board of directors members to an LLC. And in that case, the LLC agreement specified exactly how notice was to be made and included the word shall. Here, the LLC agreement states that notice shall be deemed sufficient if sent in specific manners. If not, then the notice is insufficient. So even if this court were to follow SDM's argument about the triggering event and the call right period, SDM never complied with the LLC agreement to give sufficient notice to Dr. Breault. Finally, even if it was sent properly, the check enclosed with the notice was not signed by anyone at SDM. So if Dr. Breault even wanted to accept that and try to deposit that check, he couldn't. Again, this shows that the notice did not comply with the LLC agreement. Section 7.2C requires the notice to include a closing date for purchase of Dr. Breault's shares. No such date is included, and if it is quote-unquote upon receipt, then the closing could not be consummated because the check was unsigned. As such, SDM failed to timely and properly exercise his call right, and Dr. Breault remains a member of SDM. For the reasons presented today, the appellee, Dr. Breault, respectfully requests that this court affirm the Chancery Court's holdings.
Thank you very much.
Thank you.
Mr. DiCamillo, I think you have a very small amount of time left.
Let me try to use that small amount of time efficiently, Justice Valahura. First, just going back to Section 1.3. Section 1.3 of the proposed redemption agreement contemplated that the service agreement would be terminated at a point in the future. There was no reason to put that in the proposed redemption agreement if it had already been terminated. It demonstrates that there was no mutual assent to terminate the agreement as of February 15th. The other side has no answer for that. They didn't answer it below, they haven't answered it in their briefs, and they weren't able to answer it in response to Justice LeGros's question today. And the Court of Chancery did not grapple with it at all. That constitutes reversible error. In summary, the Court of Chancery found the two emails, which did not mention the service agreement, which were sent for a different purpose, which contemplated future action, effectuated an immediate mutual written agreement to terminate the service agreement. In reaching that conclusion, the court impermissibly relied on a recital in an unexecuted agreement while not considering the important provision of that agreement, which demonstrated that the service agreement had not yet been terminated. Court of Chancery's findings were clearly erroneous and should be reversed. I appreciate Your Honor's time this afternoon.
Thank you for your helpful arguments. We will take the matter under advisement, and you may recess the court.
Please rise. Hear ye, hear ye, hear ye. All manner of persons having anything before the Supreme Court of the State of Delaware may now depart and give their attendance to the call of the court. Court is now adjourned. God save the state and the honorable court.